Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. I recently received a question that I think is interesting and we should talk a little bit about it. And the question asked whether or not a lender's pre-approval letter should identify that the buyer's down payment is coming from the sale of real property. And the answer to the question is, within the real estate industry, we can't really account for what lenders are doing. We can't create rules that the lenders are required to abide by because, frankly, it can be the wild, wild west with lenders and the pre-approval letters they write. And it's not the lender who creates either a misrepresentation or worse, it fraudulently induces the seller to enter the purchase and sale agreement by withholding information that buyer is relying on a contingent source of funds for buyer's down payment. Now, what on earth am I talking about? Form 21, paragraph A, the very first boilerplate paragraph in the purchase and sale agreement, says that buyer is not relying on a contingent source of funds unless otherwise disclosed in the purchase and sale agreement. It's not enough for it to be let me back up. Even if it was accounted for in the pre-approval letter, that's not enough. Buyer brokers, this question really should go to you. The importance of this issue rests with the buyer broker. Buyer broker, when you sit down to write an offer for buyer, you must ask the question, where is your down payment and where are your closing costs coming from? It's not enough that you might have had a discussion with a lender about where the source of your funds is. I, as your broker, have to know this information. Why? Because Form 21, paragraph A says that you are not relying on a contingent source of funds for either your down payment or your closing costs. So if you are, we have to disclose that in the purchase and sale agreement. And buyer broker, if as you're writing the purchase and sale agreement, you get a copy of buyer's pre-approval letter, and the pre-approval letter does account for down payment funds coming from the sale of buyer's real property, do not say to yourself, okay, well that resolves that issue. We don't have to cover it in the purchase and sale agreement, because that's not true. The lender's pre-approval letter is not part of the purchase and sale agreement, and the Form 21 paragraph A letter is very clear. Buyer must make that disclosure as part of the terms of the purchase and sale agreement. So, buyer broker, if your buyer is reliant on the sale of real property for proceeds for the purchase of seller's property, if for some reason your buyer does not want to include either a 22B, the home sale contingency addendum, or a 22Q, the pending sale contingency addendum, because if your buyer uses either of those addenda to account for this particular set of funds, then that resolves this issue. But if for some reason your buyer doesn't want to use either a 22B or a 22Q, they're trying to make an offer without contingencies, in other words, buyer broker, you still must, on behalf of your buyer, document the transaction to show buyer's reliance on that contingent source of funds. It's not up to the lender, or at least within our industry, we can't rely on a lender notating that reliance in their pre-approval letter. Buyer brokers, you have to document buyer's reliance on that contingent source of funds. And the form to do that is Form 22EF, the Evidence of Funds Addendum. Buyer brokers, on the paragraph entitled Contingent Funds, you would mark the appropriate box for the sale of real property, identify that the buyer is relying on funds from the sale of real property for their down payment or their closing costs. But please understand that if the buyer is already including a 22B in the transaction, accounting for that same set of funds, then you should not include a 22EF to account for the exact same set of funds. It may be that buyer has a 22B accounting for the funds from the sale of one piece of property, and buyer is also relying on funds from another property. In that case, you might have a 22B and a 22EF, but you would never use a 22EF to account for the same funds that are already accounted for in a 22B that's part of the transaction. I hope that makes sense. If it's not clear at all, or if you have any questions about this or any other topic, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.